Sure. My name is Neal Katyal, and I'm a law partner at Hogan Lovells, where I co-direct our appellate practice, and I'm also a law professor at Georgetown. Well, working in the Solicitor General's office was undoubtedly the professional highlight of my career. And in part, it's because you're walking in and you're walking into an office that has enormously talented, hardworking, respected people in there, people who are always trying to do the right thing. There's not politics in that office, and it's breathtaking. And every single day I felt like, oh my God, how am I going to do my job in front of these people, because they're so much better than I am. And that's true at the line level, and it's true at the deputy level. So it's a enormously talented constellation of people in that office. In private practice, I've tried, quite honestly, to create my own mini SG's office. And my hiring decision, I spend more time on hiring than anything else. And my hiring decisions are informed by the fact that I did the hiring process there in the Solicitor General's office for a few years. And so I kind of know how to do it. And I've basically adopted the reverse of the Court of Appeals judges, who are always clamoring to get students so early that they're like in their first year of law school sometimes, when they're snapped up by one of the so-called feeder judges on the DC circuit or something like that. I do the exact reverse. I wait until people are far along in their clerkships. I want to hear what their judges and justices think of them. I want to hear what their peers think of them. I want to hear what their summer job folks thought of them. And I'm not just trying to hire the very best lawyers and analysts. I'm also trying to hire the very best people, the nicest people, the people who are good to work with, because 100% of my work is with other firms, and I want to make sure that that is done, that people are really happy when they work with us. And so I do have a kind of SG hiring model approach here, and it's worked. So in the SG's office, I rarely got a question at the real Supreme Court that I didn't get in one of the moots, and the very same thing is true here at Hogan. Have not gotten many questions, if any, that at the real Supreme Court that it hasn't been asked in one way or another by someone at one of my moots. When you're a principal deputy SG or acting SG, it's a totally unpredictable smorgasbord of things. You have very little time to actually prepare for the arguments. You really have only the weekends to prepare. That's your weekend job. Your daily job is really hard questions about what cases to appeal, because every appeal by the United States in the 50 states has to be authorized by the Solicitor General. So any kind of, procedural appeal in, New Orleans from the district court to the circuit court has to be authorized and things like that. So that's a lot of time. There's a lot of management stuff, and then there's a lot of advice that you're giving the Justice Department more generally about complicated issues of law. And so it's a whole bunch of things, but when you look at an SG and you see them in the Supreme Court and you think that's their job, no, that's about 3% of the job. It's a visible 3%, obviously, and it's an exciting 3%, but it's a very small piece of the job. Well, I was acting Solicitor General, which meant that I was not nominated or confirmed. Elena Kagan had been nominated in May of 2010, and so I ran that office on that basis. The good and bad news about acting is you got to do everything that the Solicitor General does. It was an enormous privilege to do so. I was really lucky to have that. So the SG's office has a really kind of long-established tradition of formalized decision-making. That means that written memos, are prepared in every case by every agency and every component of the Justice Department that has an interest in the case. And you get all these memos, and by the way, they have to email them to each other. So they're all reading everything. There isn't like some secret memo that only the SG reads or something like that. Everything is shared among everyone. And then there's often long government meetings in which the memos are discussed and debated and the like. And that has impacted me greatly in watching that decision-making process. The forcing someone to formalize their views in writing crystallizes the discussion, makes it so much better than when you have people coming in without a memo, just kind of going off in their own directions. And so it's an enormously valuable part of the process. And, Ed Needler, who's the longest serving career deputy there, is a big champion of the process, a guardian of the process. I've learned more from watching Ed Needler be a lawyer than from anyone else ever. He is just such a decent and honorable and smart and astute advocate. And it was just the privilege of my life to work alongside him and the other folks in the office. So, you walk into the meeting very highly prepared. So you've read all of the different memos. You've got a list of questions, and you're asking the questions. And you're, in many ways, like a judge. You're trying to sit there, ask the questions of both sides, sometimes there are many different perspectives, and trying to figure out what's the right thing to do. But at the end of the day, when you're running the Solicitor General's office, that's a decision you've got to make, and sometimes it's enormously difficult. It is a really heart-wrenching thing, and you agonize about it, as you should, because ultimately the stakes can be extremely high. The job is not just to win a case. The job is to do the right thing. So, for example, when the Affordable Care Act litigation was going through and the Justice Department and the trial courts had made decisions to push standing and ripeness and all sorts of procedural objections, a lot of people said, we got to do that. We're litigators. Our job is to win cases. But no, the real job was to do the right thing for the country and to resolve that issue. And if there was a good argument, a good faith argument, not a kind of debater's trick argument, that all of these procedural defenses should be dropped and the country should have resolution of this really important decision, that's the thing you do. And so you make that call. And some people can't understand it because they say, no, you're going to help us lose the case. No, you're going to help the country reach the right decision. You're going to try your best to win, but ultimately you think getting a decision is more important than trying to delay the day of reckoning. Well, I think that the Solicitor General's office has a unique position of trust and responsibility with the court. And I think that the court views private advocates as being a little more hired guns. I think there's a group of us that practice regularly before that in which the court expects more from us than simply to be hired guns. So for example, I often have clients who say, please file the cert petition. I'll throw hundreds of thousands of dollars at you ultimately to file the cert petition. But you look at it and you say, there is nothing there. And yes, do I like making hundreds of thousands of dollars for my law firm? Absolutely. But the answer to that question has to be no, because I've got a relationship with the court and I want them to, understand that we're their partners. Obviously, we're private counsel, so we're not government counsel, but we are. Now, obviously, there are exceptions to that. You're representing a criminal defendant pro bono. They want to file a cert petition. That's a different matter. But if you have a company coming to you and they are often willing to do extraordinary things to get you to file that cert petition, you have to do the right thing. Well, I think it's the notion that the court is captured by a small group of Supreme Court advocates, I think, is a little bit bizarre. We're all so different from one another. We're friendly to one another, but we give each other a really hard time. And the thing about the Supreme Court is you always got one of those people, one of the people in the bar who's willing to do the case on the cheap. And so it's not as if people are going to the Supreme Court unrepresented. In every case in which you see a bad advocate at the Supreme Court, I guarantee you someone very experienced and someone very capable called that lawyer and said, hey, I'll do this case for free. So at the Supreme Court, I don't worry that certain people are being unrepresented or certain classes of folks. I do certainly have that worry at the lower courts all the time.